Counsel, you may be heard.
Thank you, Your Honor. Jacob Clabo of the Nashville Bar, representing the appellant, Mr. Thomas Baker. I'd respectfully request 4 minutes for rebuttal, please.
Sure.
Members of the court, we just heard what I would consider to be a really interesting and complex legal argument about, relatively high-minded issues that are important to the state. This case is a little bit different. This case is what appellant believes is a very straightforward contractual dispute issue with respect to the enforcement of a foreign judgment. The questions posed a couple different ways in our briefing, but the sum and substance of what the appellant's issue in this case can really be boiled down into one sentence, and that is, did the trial court err when it refused to consider his equitable estoppel defense on remand of this case after the prior appeal? And the second part to that is, if the trial court did err, or because the trial court did err, did it subsequently err or further err when it enforced the judgment in this case, or entered judgment in this case, of $47,000 and some change?
So you've raised two issues on appeal, but really it's a single issue then. It all revolves around this estoppel, whether or not the court should have considered that on remand.
Yes, Your Honor. It's we think technically two legal errors, but really it's cascading. So if you find on the first issue that the estoppel error occurred, the subsequent entry of the judgment would be an error as well.
So it's not a case here where if we disagree or we find that the court properly did not consider that on the second go-round, that there is some dispute here about the calculation, how the interest should be applied, that sort of thing.
That's correct, Your Honor. I think there is some nuance when this was argued in the trial court about how that was calculated. And I think on the prior appeal in this case, this court characterized the raising the equitable estoppel defense is not really a total bar to a complete recovery by the judgment creditor. It really was, did the defendant make payments on the judgment? If he did make payments on the judgment, how are those calculated, and how does that impact the interest calculations? I think in that respect there is a little distinction, but it still flows from the same legal analysis, which is the equitable estoppel defense properly considerable by the trial court on the remand? And there are four issues that I would briefly like to touch in my time today on this appeal with respect to this issue. The first is that the text of this court's order, and I'll call it Home Service Oil 1, the first appeal, the text of that order on its face, appellate contends, is a general remand. And if we look to the slip opinion, page 4, the operative language is the trial court properly enrolled the foreign judgment, but Mr. Baker failed to prove that equitable estoppel prohibited or limited enforcement of the judgment. We vacate the trial court's decision on enforceability and remand for a new hearing to determine the amount owed under the judgment. And that language, members of the court, leads me to my second point, which is the context that this case arises in makes that language a general remand. This is a uniform enforcement, an action under the Uniform Enforcement of Foreign Judgments Act, the UEFJA, and I'll just call it the Act because that's a lot of letters and I'll mess it up. But the Act sets out a two-step process by which foreign judgments are enforced in the state of Tennessee, and I think 48 states have adopted the Act. And under the Act, there's a two-step process well known to this court on how foreign judgments are enforced. The first step, which is recognition of foreign judgments, has to do with comity, full faith, and credit, really not at issue in this case. And then the second step, which is the enforcement step. And Tennessee case law is clear that at this second step of the process is where defendants are entitled to raise all the same procedures, defenses, and proceedings for reopening, vacating, or staying a judgment as for a court of record in Tennessee, and that's the Capital Partners case. We cite that in both of our briefing, or both our primary brief and our reply brief. And that case law is important, members of the court, because what it does is it sets out the structure that all of this is operating within. And if that structure is you have full faith and credit, we recognize the judgment, and then step two is, all right, let's figure out what that judgment is. Well, figuring out what the judgment is, calculating the judgment, determining the amount owed under the judgment, which is the language from Home Service Oil 1, That is the second step in the Act's enforcement process. And so from Mr. Baker's perspective, this is a general remand because the text of this statute, or the structure of the statute, as elucidated by Tennessee case law, is that the defenses, all defenses, should be properly considered on the second step of the appeal. And so for that reason, not only does the plain language of the remand of this case support the finding it's a general remand, but the structure of the Act supports the finding that a general remand is applicable in this case. The third point I'd like to raise, members of the court, has to do with the substance of the equitable estoppel defense in this case. And really, that was not an issue that ultimately was determined by the trial court. It was not considered by the trial court. The trial court said, this court's already ruled on equitable estoppel, and we're not going to second-guess that ruling. And it's Mr. Baker's position that that's really a misreading of this trial court's prior opinion. And what this trial court said is there are, two sets of factors that apply to equitable estoppel. There's the Cracker Barrel factors that relate to the person who's trying to be estopped, and then there's the second set of factors, which relate specifically to the person who is attempting to do the estoppel, and that's the Callahan case, members of the court. We cite both of those in our opinion. And in the prior appeal, the linchpin issue was the first of those Callahan factors, the lack of knowledge and the means of knowledge of the truth as to the facts in question. And really, the issue boiled down to here, the trial court, on the first case, the trial court found equitable estoppel. This court reversed and said, well, Mr. Baker's he's a CPA, he can do the math, he can figure out what the balance of the judgment is. And that's really not what is attempting to be estopped here. It's not this math calculation. It's the decisions and actions by Home Service Oil to cease collections on the judgment or to consider that the judgment was fulfilled. And those were the facts that were elucidated at the trial court.
But in the first appeal, that was known to the court. We were aware of the filing in Illinois. And so, it seems to me that if your argument prevails here, it would be asking us to review again that very thing that was before us. The decision clearly says that your client failed to prove equitable estoppel before, and part of that proof, I assume, was the Illinois filing by the judgment creditor here. So why wouldn't that foreclose reviewing that again?
Well, I think there's two responses to that, Your Honor. There was a second set of facts that were submitted to the trial court on remand that were not considered, and so we think that kind of flows into the law of the case and collateral estoppel points that the appellee raised.
So what additional facts would have come before the court that you're saying was not presented before in the equitable estoppel defense?
I know it was a declaration of Mr. Baker, and it can be found at the technical record, volume 2, page 211, but there's a second set of facts, right? And so the way that practically how the proceedings went at the trial court is the trial court on the first hearing looked at the Cracker Barrel factors and said, okay, we think you satisfy the Cracker Barrel factors as to the estopped party, estoppel prevails. He didn't really address that lack of knowledge as to the party attempting to assert estoppel, which is the CPA and Mr. Baker's financial background. And so those the set of facts relating to that element are what were distinct. And really, the only reason this is an issue on appeal is because it doesn't provide Home Service Oil with a basis to say, well, there's an alternative basis for them to succeed in this case, because the merits were never actually considered at the underlying court. But if they were considered, our point on appeal is Mr. Baker would have prevailed. And so back to my point, really, which is that the estoppel doesn't relate to math or the ability of Mr. Baker to, as a CPA, determine the amount owed under the judgment. The estoppel relates to the fact that there was some minor amount left, and this is all set out in the factual record. Mr. Baker paid what he thought was close to or all of that amount, and the parties never had contact for years. And so the fact that he's a CPA or the fact that he has some special financial knowledge doesn't give him, ESP or the ability to determine, hey, I need to go find these guys and figure out what the status is. So really our position is the lack of knowledge on that element.
That doesn't sound like new facts. That sounds like a different spin on the facts on this second go-around. We want to argue these to you differently, Judge.
Well, I think, so the first, I think there is a distinction, Your Honor, respectfully. I think that the first case was specifically as it relates to the math and the CPA and the financial aspect of it. And the second case is really, well, you know, the legal issue or the factual issue that comes into play with the first element of the Callahan factors is that he couldn't have known because he's not in the mind of the judgment creditor in this case, and that's really the distinction. And you know, I think that the analogy really is, you know, if you try a tort case and the trial court says, I found, you know, duty, direct cause, and damages, and doesn't make a finding as to proximate cause, a defendant would rightfully come to this court and say, well, there's no proximate cause finding. And this court would rightfully send it back to the trial court and say, there was no proximate cause finding, and you need to do your job, trial court, and make that finding. And that's kind of what happened here, Your Honor. We think the trial court failed with respect to that element. We submit, on the first instance, this court reversed. We submitted evidence as to that element, and then the trial court refused to consider it. We think that's a legal error. And very briefly, Your Honor, the last point I want to raise is with respect to the fees sought by defendant, the frivolous appeal point. We don't think that's got any merit, Your Honor. We think, one, judgment creditor should, or judgment debtor should prevail on the merits. Two, that's discretionary, and there's the issue of the fact that they filed a motion to dismiss in this court, which didn't have a legal basis, which drove everybody's costs up. But I'll reserve that for rebuttal, and I would respectfully request that the court reverse the trial court and remand to the second step of the act for enforcement.
Thank you, counsel. You have your time for rebuttal. Counsel, you may be heard.
Thank you, Your Honors. May it please the court. My name is Briggs Dixon. I don't believe I've had the privilege of presenting arguments to Your Honors Usman and Frierson. Your Honor McBrayer, I know it's on the original appeal, so it's good to see you again as well. So I want to address, I'm not going to rehash the briefing, but I want to address kind of the global picture we're looking at here. That is that Mr. Clabo is correct. This is all about equitable estoppel, which was addressed in the initial opinion from this court. Now, he presents claims that there was a general remand and that the trial court failed to consider equitable estoppel. The general remand issue I can get to later, but I really want to speak to the proof and the legal landscape and what the trial court has considered and what this court's considered with respect to equitable estoppel. Now, the most important point is, even if this court were to accept Mr. Clabo's arguments on behalf of Mr. Baker that there was a general remand, and even if Mr. Baker is correct, the trial court should have considered further, in some way, equitable estoppel, as explicitly delineated by this court's original opinion. So assuming both of those are true, Mr. Baker still fails. Mr. Baker, in his brief, stated that this court in, as they said, HSOC 1 or Baker 1, listed the elements under Cracker Barrel and Callahan, and it specifically addressed the issue on whether Mr. Baker had both knowledge but also means to know the true amount of the outstanding balance on the judgment. It went through detailed analysis, accepting the record, showing Mr. Baker's own testimony that he's a CPA and he can be expected to know how to calculate interest and the amount that would be due on a judgment. Now, everything in the record before Your Honors, including the brief of Mr. Baker on this appeal, fails to address at all that means of knowledge element. Mr. Baker has said that the court told them what they needed to do to prove equitable estoppel. It was remanded. He still submitted no additional facts, whether affidavit or otherwise, to show that he did not have the means to know the outstanding balance of the judgment. I'm a little confused on the argument today on what Mr. Baker has said means to, how means to know doesn't apply. I don't follow that, and I think that's a new argument. So I'm not sure even how to address that. But the fact of the matter is, the question is the enforceability of the judgment. Your Honor's correct. The amount due, let me take a step back. After the remand, we filed a motion to determine, or a motion for hearing to determine the amount due under the judgment. At that hearing, we presented a very detailed calculation via a spreadsheet listing by months and years exactly how payments have applied, how interest has accrued, and the trial court adopted that as its part of its order. It's in the record. That's not challenged here. So the only issue before your honors are if Mr. Baker should have been permitted to have his equitable stop defense heard, would the outcome have changed? And I'd submit that it would not. They've offered no proof, and frankly, with Mr. Baker's own testimony saying that he's a CPA and that he should be able to determine the amount due, including interest on a judgment, I don't know how he could effectively rebut or prove equitable estoppel any further, because he would effectively have to do a sham affidavit that says, well, what I said before is not really true. And those would cancel each other out, and that's a whole new separate issue. But I think it's telling that they failed to even mention it. They're trying to get away from this means to know argument. So in short, the best case scenario for Mr. Baker on this appeal is for this court to find, well, the trial court should have considered it further, but the facts in the record demonstrate that he's offered nothing to establish this element, that he didn't have the means to know what the outstanding judgment was. Now, HSOC, or my client, has argued in its brief that the appeal was frivolous and completely devoid of merit. And we filed the motion originally before the briefing. That was denied. Frankly, at this point, I don't think that it matters. We filed the motion, and I wanted to address this. We filed it because we felt that it was frivolous at that time based on what had occurred in the trial court, and we wanted to prevent fees from accruing through the appeal, and we thought it was clear at that point. I think since the filing has been made, there's been a lot of extra noise, but the issue is still, can he prove equitable estoppel? But at this point, whether it's dismissed or not, we've already incurred the fees, and the fees are also something that's recoverable through the original judgment and collection. So I don't think that's really an issue anymore. But we do think that the appeal's frivolous, and I would say that the facts that have come before your honors today establish that Mr. Baker knew what the elements were. He knows what he put before the trial court on remand, and one of those elements that he was supposed to present proof for, if he was going to pursue that defense, was means to know that he did not have the means to know the outstanding balance of the judgment. He failed to do that, and he's still appealing, attempting to have this court send it back for what reason, I cannot discern. We'll have a third record, and at that point, I think there's nothing else that can be added. So I'd submit there's no basis to find that Mr. Baker had any belief that he could prevail on these facts. I think it takes a strenuous legal argument to get there, and something that I think has frankly not even been argued in the trial court below to this point. Now, I do want to address just very briefly the general versus specific remand, because I said before your honors, you can accept that as true, and I think home service order should still prevail for the reasons I've said. But Mr. Baker, in arguing for a general remand, focuses on Section 3 of this court's original opinion that states, we vacate the trial court's decision on enforceability and remand for a new hearing to determine the amount owed under the judgment, end quote. That's what he relies on. What he ignores is the paragraph and sentence immediately preceding that. And this court specifically explained, quote, a new hearing is necessary to determine how interest should be calculated on the judgment and how payments should be applied. That's the portion of the enforceability aspect that was not clear. And the reason it was not clear is because we were dealing with, were and are now, a Missouri judgment in which Missouri law applies. And it was unclear whether attorney's fees and court costs should be included in an amount that accrues interest. It's since been not argued by Mr. Baker that the attorney's fees and court costs do accrue interest. That's part of the detailed spreadsheet that was made part of the record for the court. And I would submit that this court specifying the reason for a new hearing and then immediately saying they vacate the judgment or they remand for a new hearing to determine the amount owed under the judgment, consistent with that language, is a specific remand. That's the bulk of my argument. If you have any other questions, I'm happy to address them. But at this point, I think it's clear that the trial court should be affirmed. Mr. Baker's arguments for equitable estoppel are without merit. And if I don't have anything further, happy to address it.
No further questions. Thank you,
Thank you, Your
Counsel.
Honors.
Counsel, you may be heard.
Thank you, Your Honor. Very briefly on rebuttal, I think 2 points that are important for the court to consider. The first is the lack of means to know, because this argument was certainly raised at the trial court. I think I gave us a cite to the technical record where that was evidentiarily raised at the trial court. The law under Callahan is lack of knowledge and of the means of knowledge of the truth as to the facts in question. I think the dispute here is that Home Service Oil believes the facts in question are the outstanding balance on the judgment. And what Mr. Baker contends are the facts in question is the amount sought by Home Service Oil in 2014, I believe, as to the amount on the judgment.
But we don't get to those issues unless we agree with you that this was a general remand.
Yes, Your Honor. And so I think that's the distinction as to the means to know, and we think that was appropriately raised. at the trial.
Excuse me for interrupting, Counsel.
Yes, Your Honor.
What additional evidence, if any, was proffered?
It was a declaration of Mr. Baker, and it's page 211 of the technical record 2. I can't remember the specifics, and I was trying to find it in the briefing as I was sitting over there, and I didn't have a chance to. I know one other issue we had was, in our briefing was we had an evidentiary hearing the first go around in this case, and we didn't have one the second go around. In that case, Mr. Baker testified, and certainly that's a place where those specific facts would have been considered or would have been elucidated had we had the opportunity to present them. And that, Judge McBrayer, leads me to my second point, which is on the specific versus general remand. And as this Court's aware, that's generally the two categories of remands that exist, but really the case law says a remand can take one of several forms, right? And I think that was the Consumer Advocate Division case we cited too. It can dictate the course of further proceedings. It can be open in general, or it can be made for a specific purpose. And really, that's one way of saying that each remand is kind of specific in that it's for its own case, right? So it doesn't necessarily have to be a broad, wide open general remand for Mr. Baker to prevail. And I want to clarify, I guess, Judge McBrayer. In this case, if the specific remand is to go back to step 2 of the Uniform Enforcement Act, if it's to go back to that step of the process, that could be a specific remand, but it would still entitle Mr. Baker to present all of his defenses consistent with the case law governing that act. So it could be specific, it could be general, but from our reading of that order, there was nothing in there that said you are prohibited from ever raising this defense. And we think if this Court had made that argument.
So, it's fair to say that your argument is, well, this could still be a specific remand in the sense that it focuses only on enforceability.
Yes, Your Honor.
And not enrollment, but it's still not specific enough to foreclose a new evidentiary hearing.
Yes, Your Honor. And we raised this issue in our reply brief. There's instances of remand where the court will remand and say, okay, trial court, I want you to exchange the consideration back for this contract. I think it was $500 in a piece of land in that case, and I can look up the case site if the court would like. But there are those types of specific remand which says go back and do this specific thing. In this case, the specific remand says go back and calculate the amount on the judgment. And based on Tennessee case law governing the Uniform Enforcement Foreign Judgments Act, we interpret that language to mean go back to step 2 of the act and do what you should have done in the first case trial court. And for those reasons, the appellant respectfully requests that the trial court again remand this case, or the Court of Appeals remand this case to the trial court for consideration at step 2 of the act.
Thank you.
Thank you, Your Honors.
We thank counsel, any parties, and others for being here today, and that will conclude this morning's hearing. Madam Clerk, could you please call the next case?
John Pearl doing business as Third Coast Builders versus the Tani Group LLC et al.